Golf Central on YouTube, brought to you by the Rogue ST Woods and Irons from Callaway.
Hi, I'm Amy Rogers, and this is your Golf Central update. Breaking news today regarding the PGA Tour. Phil Mickelson, Bryson DeChambeau, and 9 other LIV Golf players have filed an antitrust lawsuit against the PGA Tour. The suit challenges the suspensions the PGA Tour have implemented, not allowing the LIV golfers to play in PGA Tour events. In addition to Mickelson and DeChambeau, the other players in the lawsuit, Abraham Ancer, Carlos Ortiz, Pat Perez, Ian Poulter, Peter Uihlein, Jason Kokrak, Taylor Gooch, Hudson Swafford, and Matt Jones, all of whom have already played in at least one LIV Series event. Jodi Balsam, professor of clinical law at Brooklyn Law School, joined Golf Today to talk with Damon Hack and Eamon Lynch.
Jodi, this is obviously something that is going to be unique compared to other antitrust lawsuits, but what stands out to you about this specific case?
Well, in this case, you have claims that an existing sports entity is taking measures to prevent competition by an upstart rival tour, here, LIV Golf. And the claims at face value seem somewhat valid. PGA Tour is limiting LIV Golf's access to its most important input, which is the PGA Tour level players, the elite golfers, who are having to make a Hobson's choice. Do they stay with the PGA Tour or take the cash and play with LIV Golf? And LIV Golf's position is that they can do both, and the PGA Tour obviously doesn't want them to.
Now, Jodi, there's 2 distinct aspects to this case. Now, we have 3 golfers seeking injunctive relief to be allowed to play the FedEx Cup playoffs next week, and then 11 in total who are suing as part of the antitrust case. Let's deal with the seeking of the injunction. What are the key considerations for those players to justify getting that injunction for next week? Right.
So what they are now trying to do in federal court in the Northern District of California is play in the FedEx Cup tournaments that are upcoming, right? They don't want and don't expect to get a final resolution of their antitrust claims, but they want the courts to, at least pending the litigation of those claims, prevent the PGA Tour from keeping them off the golf course. And the standard that the court will apply asks a couple of important questions. First, the likelihood of success on the merits of the player's claims. How strong are those claims? Are those meritorious claims? And second, even if they are meritorious, can they be remedied by monetary damages at the end of a lengthy litigation, or are the harms the players are confronting right now so irreparable that there needs to be temporary injunctive relief stopping the PGA Tour from keeping them off the golf course?
Professor, is there any comparison in this case to maybe a case in the past? For example, Maurice Clarett, in 2003, suing the NFL. He wanted to turn professional, less than the 3 years out of high school. He was 2 years out of high school. Does this PGA Tour case, have any kind of similar characteristics to something we might have seen in the sports world years ago?
Well, you're talking about 2 cases which are similar in that they both concern eligibility rules to participate in athletic contests and professional sports. Where they differ is that Maurice Clarett was suing in a unionized environment. And because the professional team sports in the United States, their workforce, the players, are unionized, they are entitled to what is known as an antitrust exemption. There is an exemption for unionized workplaces from antitrust challenge for precisely these types of complaints about eligibility rules. That's not the case with the PGA Tour. PGA Tour golfers are independent contractors. They are not employees who can even attempt to unionize, at least not at this point.
Jodi, obviously the longer-term antitrust lawsuit that's been filed here, that's a much more complex situation than the injunctive relief being sought. How do you see that one playing out in terms of the arguments that either side is likely to make before the judge?
Well, antitrust scrutiny asks in the first instance, does the alleged bad actor have market power? You need to define a marketplace in which they operate, as well as the competing firms operate, and then identify whether they have power to manipulate that market, to prevent others from entering or succeeding in that market. And the PGA Tour's response here is that if and when we ever have had market power, we certainly don't against the deep pockets of LIV Golf, backed by the Saudi government. That whatever market power we might possess in an ordinary professional golf setting, we don't when we're up against unlimited funds to outpay us vis-a-vis our players.
Jodi, this story has dominated the summer, and now we have a new step, this lawsuit. Typically, how long would it take for a case like this to even be adjudicated?
Years. And I'll give you as an example the Alston case that recently reached the Supreme Court after 6-7 years of litigation. And by the way, I mention that case because it originated in the Northern District of California and can partially explain why the LIV Golf players decided to bring their lawsuit there. That court has been sympathetic to claims like these in the past and gave victories to the student athletes in the Alston antitrust litigation at every step of the way.
Jodi, how do you think the injunction part of this legal action is likely to play out? And I know a lot of it depends as much on the whims of the judge that is drawn for this case as anything else. But when you look at the likelihood of these players being able to force their way legally into the field next week, what is that likelihood? And are they the only three who could make their way into the field because they are the only three who are associated with the injunction request? Or if they succeed, does that open the gates for other players who are eligible next week as well?
Well, you packed a lot into that question. Let me just start with the likelihood of them winning injunctive relief. We have the example of the Scottish tribunal a couple of weeks ago who awarded similar injunctive relief. The question there is that these athletes have short-lived careers. Some of them, they rely not just on the compensation that they earn from playing in golf tournaments, if they even perform well enough to justify prize money, but for the rankings, the glory. There's an argument for irreparable harm here, that if they are not allowed to play, monetary damages would not put them in the same place as they are entitled to be should their antitrust suit succeed on the merits. So I would say that given the ruling of the Scottish tribunal a few weeks ago and the fact that we're in this particular location in the Northern District of California, they have a pretty good shot at injunctive relief, temporary injunctive relief, to allow the litigation to take its course without impairing their viability as professional athletes. However, that applies only to those players who actually sought the injunctions, right? So players who have not brought a case and made their arguments to this court would not automatically be entitled to that kind of relief. However, it would be likely that any award of that kind of relief to any number of players would set the stage for some sort of negotiation with the PGA Tour to accommodate LIV Golf pending this litigation.
Jodi, this is an extremely complex story. Thank you so much for your time and unfolding some of the layers for us on this Wednesday.
Happy to be here.